Okay, I'm going to speak in Spanish. Pasamos al punto 17 del orden.
Moving on to item 17 of our agenda, the public hearing on FATCA and its extraterritorial implications for EU citizens. It's a true pleasure for us to welcome you to this public hearing on FATCA and its extraterritorial impact on EU citizens, organised by the Committee on Petitions. I would also like to welcome our colleagues from the Econ and Libe committees, if they're here. I'd like to thank them for the work they have carried out on this subject so far. We are looking forward to their contributions to this debate. We would now start by welcoming the petitioner, and the petitioner would now start with a statement, a 10-minute initial statement. The petitioner, where are they? You're welcome, and you have the floor for 10 minutes. Thank you very much.
Thank you, Madam the President. So I'll start immediately with my petition, or my introduction to my petition. I thought it'd be helpful. There's a lot of new faces and a lot of familiar faces here today. I thought I'd just give you an abridged history of my petition, which has been running for just shy of 5 years now, and a quick history of events so that everybody's fully aware of what's going on and what's happening and isn't happening, as it were. And a little bit the response of the European executive bodies. So I submitted the petition on the 1st of September 2016. The petition was pre-GDPR, and one of the fundamental matters of the petition is how FATCA, a US piece of legislation, breaches European norms and in particular data privacy rights in the EU. One of the key points in the petition is this concept of proportionality. I won't take people through the petition again, but fundamentally what we demonstrated, I think very eloquently, was that this bulk transfer of information from the European Union regarding European citizens to America, where there's no notion of any form of impropriety, just does not satisfy the requirements of proportionality and is probably and arguably therefore invalid under EU laws. And this is pre-GDPR. The GDPR position only serves to reinforce that message. Since I submitted the petition in 2016, however, we've been relentlessly trying to get official positions from the European executive on these issues, whether it's the Commission or whether it's the European data privacy watchdogs, the Working Party Article 29, now replaced by the European Data Privacy Board. And so over the course of 2016-17, I sent multiple emails, letters, in relation to my petition. They were all ignored, copiously ignored. I then had to go to the extent of filing a complaint with the EU Ombudsman to try and get the EU watchdog authorities to give me an official position on FATCA and its compatibility with EU data privacy norms. And on the 8th of February 2019, I finally managed to get an official response from the Working Party Article 29, so we're talking 3 years later, and fundamentally that response totally sidestepped the matter. They refused to actually look into the legality of FATCA and its compliance with European data norms. And so GDPR then came into force. Thanks to this petty commission and the work of the European parliamentarians present today, a report was commissioned by Professor Garbarino, a leading scholar in these issues, and he highlighted multiple infringements of GDPR resulting from FATCA. I sent all this information on to the now reformed Working Party Article 29 that had become the European Data Privacy Board, trying to get, again, their response. And I produced their email back to me. So in 2018, this was the response of the European Data Privacy Board. Dear Mr. Ryan, FATCA is an ongoing project and no decision was reached by the members of the board. We cannot comment further at this stage. We also cannot say at this point when a decision will be reached. Thank you very much. So I'll just leave that in terms of the position of the EU watchdogs. This absolutely fundamental point of compatibility with EU data privacy norms is just not being looked at. And I know the European Data Privacy Board is present here today, so hopefully they may be in a position to enlighten us a little bit further. I would say that this position is only compounded by the resolution that was voted by the European Parliament in favour of accidentals. And in that resolution, the Parliament asked the EDPB to hold an investigation into the GDPR issue, but that has simply not happened. The second limb of our petition, I suppose, is more as regards the position of other executive bodies and the European Commission in particular. And so the Commission has come to all the hearings that have been held thanks to Petty on this subject. And we've seen basically a systematic kind of stonewalling of all our requests and all our attempts to actually have the issues that we're raising properly looked at. The Commission has sent junior members of staff. The Commission has hidden behind easy arguments over a lack of data, just to avoid effectively looking into the real issues. And I'm going to take a little aside here. One of the things I think is very important for the Commission to note today is that we have 25 people here today, 25 accidental Americans who've come on their own time with their own money from Belgium, from Ireland, from Austria, from Holland, from France, from the UK, and I'm probably forgetting some countries. So this is a real issue. These people exist. They are here, physically present here today. And so the Commission has ignored the issues. I can surmise why the Commission might be doing this. It could be driven by political factors. It could be a reluctance to stand up to the US and actually assert European norms and the rights of European citizens. It could be for political gain. It could be this notion that if you bring down FATCA, you bring down CRS, the Common Reporting Standard, and that FATCA is ultimately good because it's going to solve budgetary issues by fighting international tax compliance. But the underlying point of all this is that an executive should not overlook breaches of European rights and infringements on the rights of EU citizens for political gain. That point must be understood and must be acknowledged. I find personally that the position of the Commission, and I will speak my mind here because I've been coming here for 4 years now and nothing's happened, is callous and short-sighted. It's callous because you are ignoring your citizens and you are turning a blind eye to the breaches, flagrant breaches of EU norms. And it's short-sighted because fundamentally what you are doing is damaging the European project. I am a fundamentally European citizen. I'm half French, half Irish. Every Saturday morning, I take my kids to tennis and I walk them down Boulevard Flandrin, where Jean Monnet, from 1955 to 1975, built this project. By ignoring your citizens, by turning a blind eye to them for political gain, you are damaging the European project. And I say that as a passionate European citizen. I'm very pleased to see that there is a very strong, lively European Parliament that is standing up for us and that is listening to us. And this is important to me because the Commission is not listening to us, myself as a petitioner, but the 25 people that are here as well. But equally, it's not listening to the European Parliament. In Resolution 2018-2646, the European Parliament asked the Commission to do various things, and none of those things have happened. The Commission has not investigated the issues represented by FATCA. The Commission has not spoken to us. It has done nothing. And it'll probably come here today and say, it's a US issue, we can't do anything about this. We shall see. I hope I'm wrong. Oops, I've lost my slides. But the last bit I just wanted to do was show, in a kind of slightly more positive note, what can happen when an executive wakes up and does something. And we have some very, very interesting recent illustrations of what can happen, if I can get to the last slide, which is not appearing. But we have strong political action in France. I can see Monsieur le Député Le Fur is present today, and Saint-Martin have done an incredible job of moving things in France. Similarly, in the Senate in France, Jacques Deromedi had a resolution passed. France is moving things forwards and showing that things can happen. Equally impressive is what's happened in Holland. Mino Snell in the Ministry of Finance went to America. What happened when Mr. Snell went to Washington? The Americans acknowledged the existence of accidentals, and the IRS, even very shortly thereafter, came up with a partial amnesty for Americans. It's not perfect, and it's not the solution that we want, but it shows to the Commission that when you act, the Americans are aware, listen, and respond. So this hand-washing is just too easy and cannot be accepted. We also know that domestic politicians are waking up. Unfortunately, I think Preet Kaur Gill, the UK MP, was invited today and she cannot attend, unfortunately, but we know that these people are listening and that basically there is a groundswell. There are lots of domestic politicians wishing to act. It's now really just up to the Commission to pick up the baton, accept to do its job, protect its citizens, protect EU norms. And that's really what I want to finish with, which is kind of a reflection on the separation of powers a little bit, if you will. We have a European legislative body that has been supporting us for 4 years. I can see Sophie, I can see Jude, I can see all these people who have been instrumental in helping us. And thank you, my heartfelt thanks to you. As European citizens, we thank the European legislative. We have a European executive that won't even listen to us. And so us as citizens, what we will do is we will listen to the basic rights of the separation of powers. And what the separation of powers tells us is that when the executive fails in its mandate, we can turn to the judiciary. And that for me is a nice segue today, because I'm sure we will hear from Filippo, who's present here today, and Jenny, because they are actually doing what needs to be done to protect European citizens, which is saying, European norms are breached by FATCA, the judiciary will recognise this if the executive fails. And so I think we'll also hear from Filippo today, which will be, I think, very insightful, because we can hopefully count on the European judiciary in addition to the European legislative. So that's just my little introduction. Thank you very much.
Thank you very much. I now have the honour of introducing the first panel on financial services. The three speakers will be Mr. Laurent Saint-Martin, Member of Parliament in France, Mr. Roger Janssen, Deputy Director of International Affairs and Consumption Taxes of the Ministry of Finance of the Netherlands, Mr. Roger Kaiser, Senior Policy Advisor for Tax and Compliance for the European Banking Federation. I now hand over the floor to Mr. Saint-Martin, and each speaker will have 10 minutes for their statement. Thank you very much and welcome.
Madame la Présidente.
Thank you very much, Madam Chair. Ladies and gentlemen, with my French colleague Marc Le Fur for about 18 months now, we've been in contact with some of our compatriots who are called accidental Americans, and we have been discussing the issues connected on French territory of this discrimination. I say that by way of an introduction because it's very important to understand nowadays how parliamentarians can help these people. It's not something that we're not aware of, this extraterritorial effect of American legislation. So we have focused on this issue because many people have flagged it up to us. And Mr. Fur, who represents Brittany, I'm from Val-de-Marne, near Paris. That's the constituency I represent. And we've heard from French families in other regions, other people who have dual nationality, French American. So with Marc Le Fur, we have spoken to the President of the Finance Committee, and we've been in contact for about a year. A report has been drawn up in May 2019. We've had various hearings in Paris, for example, with the various stakeholders, as well as accidentals themselves and the Association of Accidental Americans. And I'd like to welcome them here and congratulate them on the work that has been done with the Foreign Ministry and the tax authorities. We've also been working with the French Banking Federation and the French Parliament, some members of the French Parliament, Frédéric Lefebvre, for example. We've now come here. We came here also in the past, and we interviewed Madame Rosière and Madame Beres, two members of the European Parliament, French members. We've also met with members of the Commission, the relevant DG, Tax DG, Customs and Financial Stability Authority, as well as Union of Markets and Capitals Authority, as well as consumer representatives. Now, when we spoke with the European Commission, the issue was taken on board. The subject is understood. But, of course, there has to be some involvement and cooperation from the member states. And there we find that we're at a sort of deadlock. We spoke to the European Banking Federation as well, and Mr. Kaiser is here today. We went to Washington to meet with the Americans. The Internal Revenue Service in particular, their tax authorities, as well as Treasury representatives and members of the Department of State. We also took advantage of this visit to meet with members of the Senate, the American Senate. We met members of the American Senate who were very concerned about these extraterritorial consequences. So the Americans themselves have an awareness of this kind of banking discrimination, and some of them have experienced these problems, and so we were able to find some common ground, and hopefully that will continue in the months to come. Well, I believe that there is a need for information to be disseminated about this issue because it's a particularly unfair, unjust situation, and you're all aware of it here in this room. We have dual nationality people who have quite accidentally, perhaps by birth, acquired American nationality. And this is not, however, just their problem. It concerns other dual nationals, perhaps people who have gone to the United States subsequently and have never used public services there. So we have the 14th Amendment, which flags up this issue, that you are eligible to contribute to the American system, tax system, when you are an American, if you have American citizenship. So you're all aware of that. Now, the specificity in France, and this is something that we discussed with Marc Lefur, is that why we have so many accidentals in France, perhaps fewer in other countries, but perhaps my neighbours in the Netherlands can enlighten us further on this. But in any case, the banks in France have been very zealous in applying FATCA. I've only got 10 minutes, so I'd like to go a little bit quickly here, but we have to think about why these Franco-Americans have been discriminated so much by the French banking system. They can't open a bank account in some cases. Financial products, their access to them is problematic. They cannot get a mortgage. So very everyday issues that they're having difficulty with as citizens. So we believe, given the volume of the French banks, the big French banks who have a lot of trade with America in dollars, they want to be compliant, of course. They're very zealous in that regard, and we understand that. We understand they want to be in compliance, but at the end of the day, we have an intergovernmental agreement in France that these banks have signed this agreement with the United States, and it is actually discriminating against French citizens. That's something we cannot allow to continue, and I hope that we can settle it at European level. I have 3 minutes left, says the speaker, so I'd like to look at the proposals that we think would be appropriate. We have some proposals that have been, we'd like to see agreed on at European level. I'll come back later to what we can do at the American and French levels. But the first proposal at European level is to put it on the Council of Ministers of Finance. And in May, as I said, there was a high-level group on tax matters at the Council, and there's another meeting on the 28th of October. And the second proposal concerns the Regulation 2271 and the extraterritorial effects of FATCA. With the United States now, we would like to negotiate with them a revision of the thresholds of revenue, of income and assets regulated by FATCA, so that we can have a better declaratory situation. We understand that there is tax fraud, tax evasion, and that is obviously a very laudable objective. But we don't want these thresholds to penalise our compatriots. And we would also like to bring up to date the agreement between France and the United States in terms of double taxation, and access to the possibility for a dispute settlement in terms of fiscal disputes. And when we go to the actual French situation now, we have a lot to do there. We have the CPR. We'd like to give them more powers so that they can tell the banks to give reasoned opinions as to why they have taken certain decisions, or proceed to mediation, or withdraw from that. So, ladies and gentlemen, what we're trying to do is avoid this kind of discrimination in our country on the part of the banks. We understand that we can't do this in a long-term sustainable way unless we have reciprocity, and if we don't bring the European Union on board so that we can form a bloc with all together against the United States on this. Thank you.
Muchísimas gracias.
Thank you very much. The floor now goes to Mr. Janssen for the same period of time. That's 10 minutes. Thank you very much and welcome.
Thank you very much, Chair. And first of all, I want to excuse State Secretary Menno Snell, who isn't able to be here today, but he very much welcomes this hearing as more EU action is needed on this file. He has been very active personally on this file. He fully understands the frustration and the stress and the concerns of this group. And he made several efforts towards the US and the Dutch banks in the interest of the accidental Americans. Well, maybe to start where we stand now, I think that the starting problem is the international divergent US tax system. They tax their citizens worldwide on the basis of nationality, and that goes together with what we know, that it is very easy to become a US citizen by birth, and these are people that sometimes have very limited ties to the US. The US FATCA legislation causes, of course, also problems in my country, and I want to state here that it's not the EGA that causes the problems, because that's only an facilitation to have the information going from the financial institutions to the USA. Under FATCA, the Dutch banks have an obligation to provide information about US persons who hold a bank account, and this includes US TIN number. And if no TIN is submitted by the account holder, then the account reported is reported to the IRS without a TIN. And it's important to note that accounts containing less than $50,000 US do not have to be reported. Well, in my countries, the banks are very eager to get all the TINs, and they are even at this moment threatening account holders that they will be debanked if they don't submit a TIN to the bank, because they are afraid that they will get huge US sanctions, making it for them impossible to do the business in the US. But at the same time, some of the dual citizens in the Netherlands never had a US passport, they don't have a TIN, and they have very limited ties to the US. And they are reluctant to request a TIN and or to submit it to their bank. And furthermore, it's the case that requesting a TIN seems to be a very difficult process for these people. This is also the case for filing a tax return in the US. What we understand, that it's a very complex system. People have to require advisors, and that's a very costly procedure. And at the end, in very few cases, they will have to pay tax in the US. So we have this huge system. It's very costly, very complex, and in the end, tax due in the US is in, I think, over 90% of the cases is zero. Well, then on the numbers, we have at the moment been reported by the banks that they have 4,000 dual citizens in the Netherlands without a TIN, but only 400 of them have a bank account of $50,000 or more. And like I said, banks are threatening some of these account holders that they will be debanked if they don't submit a TIN. But at the same moment, of course, we know that because of EU legislation, banks have to offer accounts to EU citizens. Well, then on what we have done as the Netherlands on this file, as said, my State Secretary has been very active on this file. So on a political level, we have done a lot. It started already in 2016 that the State Secretary has sent 2 letters on FATCA to his colleague at the US Treasury. The Netherlands is, together with France, I think, the driving force behind EU action. There was a joint letter on FATCA sent to the US by the EU Council in 2017. And as we speak now, a new joint letter is being prepared by the presidency of the European Council, and we hope that will be sent soon to the US. My State Secretary has been in contact with the Dutch Association of Banks many times, and quite recently he has urged them not to close bank accounts of accidental Americans. Furthermore, Mr. Snell has visited Washington in May. The main reason of his visit was the issue on FATCA that is on the table here. I was able to join him, and he has spoken to Treasury, the IRS, and members of Congress. And, well, he made very clear that the problems that the accidental Americans are facing in Europe about the stress they have, it's very difficult to explain to them that they have to file a tax return in the US. And he has urged them to make the procedure easier and less costly, and also make it possible to renounce their citizenship in an easier way, and to lift the tax obligations where possible. And of course, at the same time, he and also my team has contact with the IRS and the embassy on these issues all the time. Then where do we, what are the recent results? Well, first of all, we had the transitional period on bank accounts in 2017, 18 and 19. That is ending now. So during that time, a TIN didn't have to be submitted. What we have now is that we have a Q&A from the IRS stating that potential sanctions are not there at the moment. It will only be concerned at the earliest in 2023. And in a case of concerns by the US on the reporting without a TIN of the banks, the bank will have ample time to correct this situation. Based on this, we estimate the risk of sanctions being imposed is very low if the banks are do their best to obtain the missing TINs. So we think closing banking accounts now is premature. Furthermore, on the 6th of September, the IRS published a new policy which states that under certain conditions, tax liabilities will be waived when the American citizenship is renounced, and at the same time they made clear that that this procedure also makes it possible for foreign citizens who also have the American nationality to apply for the certificate of loss of nationality procedure without a TIN and with limited American tax return obligations. And at the same time, we have with the American consulate in the Netherlands, we have now the system that if someone applies for this procedure, he gets a statement from them and he can show it to their bank, and then the bank knows that there is no TIN required. Well, to conclude, we think that these recent results are very useful, are steps in the right direction, and will help the US persons and the banks. But we are not there yet. And of course, the best option would be a change in the US tax system. But, well, I think, well, at least in the short run, that is an unlikely outcome. So I think for now, what we advise to dual citizens is to act soon, so they can choose to say, well, okay, I want to renounce my citizenship and I want to get rid of all of this. And otherwise, if they want to remain a US citizen, well, then they have to submit a TIN and file a tax return every year. We still have, for the short term, 3 issues concern we are raising to the US, and we think we should raise them at the EU level as well. First of all, the fee to renounce your citizenship is $2,350. This is very high. It used to be $450. We think this fee should be lowered. Then secondly, we think that the requirement to file a tax return should not be there in all the cases. And it's also a very difficult system. So we ask them to waiver them in normal cases and in cases where it's needed to simplify the system. And the third issue we are asking from the US is to make even more certain for the banks what they have to do to be sure that sanctions will not be triggered, because that will make them more open to keep on serving the dual citizens. So I think it is important that we keep on raising our concerns, keep on asking for these measures, not only on the national level, but also on the EU level. Thank you very much.
Muchísimas gracias.
Thank you very much for that very clear presentation. And now the floor goes to Mr. Kaiser, who also has 10 minutes. Thank you very much.
Thank you very much, Madam Chair. Allow me first to put the debate into the context of tax compliance. Over the last decade, the fight against international tax fraud has become a key priority for governments, policymakers, and tax authorities across the world. It is today a very important item on the agenda of this Parliament. FATCA, which stands for the US Financial Accounts Tax Compliance Act, and the subsequent intergovernmental agreements, the IGAs, aim to fight against tax evasion from a US perspective. FATCA targets US taxpayers who hold their assets via offshore financial accounts or shelf companies, and who may want to escape their US tax obligations. FATCA relies on foreign intermediaries, including both financial institutions and other foreign entities. In a nutshell, FATCA imposes 2 major compliance requirements on foreign financial institutions. First, a financial institution will review its client base, applying due diligence procedures in order to identify the US reportable accounts, including individual US persons and non-US entities which are controlled by US persons. Second, the financial institution will have to report these clients to the US tax authorities, mostly via its own tax authorities, the local tax authorities. Beyond the US perspective, FATCA has been the incubator and catalyst for the development of an international automatic exchange of information system, which has been elaborated based on the OECD Common Reporting Standard, the CRS, and the revised EU Directive on Administrative Cooperation, DAC2. Altogether, FATCA, the IGAs, the CRS and DAC2 form a legal framework establishing an international tax reporting system which aims to fight against cross-border tax fraud. As European Banking Federation, we strongly support the fight against tax fraud. Individually, European banks must abide by the law and strictly comply with tax regulations. In particular, a European bank which has operation in the US or even simply markets US financial products cannot afford facing the risk of being considered non-compliant with FATCA, since it could be penalized with the 30% withholding tax on all income streams from the US. Having said that, over the last 10 years, the European Banking Federation has been engaged in a constructive dialogue with governments and tax authorities on the two sides of the Atlantic. We have continuously drawn the US Treasury and the IRS attention to implementation challenges faced by European banks and in certain cases by their clients. We have always tried to propose pragmatic solutions to overcome the problems and dilemmas faced by banks in their efforts to comply with the sometimes contradictory obligations from various regulatory frameworks. The first recurrent difficulty with FATCA concerns pre-existing accounts. FATCA requires financial institutions to review their client base in order to identify US reportable accounts based on defined US indicia. When an indicium is found, the account holder is presumed to be a US reportable account holder unless information, including self-certification and corroborating evidence, is received by the financial institution that the client is not a US reportable account holder. According to FATCA and the IGAs, it is mandatory to include a US tax identification number in the reporting of US reportable accounts. Failure to report such tints for such pre-existing accounts may result in a bank being considered as in significant non-compliance with FATCA. In their attempts to collect such information from their customers with US indicia, financial institutions have faced a number of difficult situations. Notably, some clients have never answered, or they have answered that they had difficulties to obtain a tax identification number. It has notably been the case of dual national, the so-called accidental Americans, who have been granted automatic citizenship under US civil law because they were born in the United States and left almost immediately, so they lived most of their life outside the US. And they are now facing burdensome administrative requirements, and they are required to provide a tax identification number. A similar problem happens when opening accounts. Upon opening a new account, the client has to sign self-certification, and if this person has a US birthplace, then he would either have to confirm that he or she is a US person and will then have to provide a US TIN, or she will state that it is not a US person, in which case he or she must provide a copy of the account holder's certificate of loss of nationality in the United States, or alternatively a reasonable explanation of the reason why he doesn't have such certificate. Now, let me try to conclude on the last initiatives from the US, and let me provide some recommendations. Following a long-standing advocacy by the European Banking Federation, the US Treasury published in 2017 Notice 2017-46, which has provided for a grace period of 3 years. It will terminate next month. During this period, the failure to produce tax identification numbers will not automatically entail the status as a compliant financial institution. Now, there are conditions for that. The foreign financial institution has to report the date and birth of the client, and it has to make annual requests for the obtain of a tax identification number. As I've just said, we are very close to the end of this grace period, and that's the reason why we have visited Washington several times this year, and we have sent a number of letters. And mid-October, we were, I would say, quite happy to read a note from the US Treasury, which took the form of a frequently asked question, which provides some relief. However, this note has not the formal the form of a formal notice. It is quite unclear, and the financial institution remains under scrutiny. So what we absolutely need is that we should obtain a very clear formal extension of this relief. The ideal situation would be to obtain a permanent solution. Also, there should be an extension to include consideration for financial institutions to which IGA Model 2 apply. Solutions should also be considered for new accounts and onboarding procedures. So we very much hope that the US authorities will finally be ready to reopen the discussion about the IGAs, and that's something that we would very much support. I'm happy to answer your questions. Thank you.
Muchísimas gracias por su intervención.
Thank you very much for that presentation. We're now going to have some comments, questions from the members of this committee. Who would like the floor?
Kirton Darling.
Yeah, thank you very much. And thank you to all the petitioners and accidental Americans for coming to the European Parliament this morning. First of all, before I ask my question, it's very understandable the frustration that Jude Ryan started this morning with, considering that we've been talking about these issues. I mean, I look at Sophie, we've been talking about these issues now for years, raising pretty much the same questions consistently. We now are facing this deadline, which we've just heard from the European Banking Federation. And the action from some member states is laudable, but the inaction from European institutions in general is really disappointing. And I think that has to be recognised, and we should be very, very clear about it. I count myself, I have a lot of sympathy for these cases because I'm an accidental Tanzanian. I wonder what the attitude of the EU would be if we were talking about the citizens of another country than the US, whether there would be a different attitude in these these questions, and I think that's an added frustration for lots of the people concerned. So we are facing this deadline in just a few months. In just a few weeks. We've heard that there is some discussion inside the council, some very basic action. It would be interesting to hear, particularly from the representative of the EBF, because clearly you've been very engaged in advocacy work, whether you think there's really any potential for that clear formal extension of relief that you mentioned at the end, whether you see an opening and how, because as Jude said at the beginning, the other Jude said at the beginning, we've been putting pressure from the European Parliament now for years. What you think the trigger will be from the position of the speakers to get the European Commission and the Council of Ministers to act far more assertively, because it seems to me that that's where the movement has to come from. So that would be my question to those speakers.
Thank you very much, Mr. Peter Jagg.
Ja, vielen Dank.
Thank you very much. Thank you to the petitioners and experts. Thank you for this hearing. I think it's really important to try and understand the situation and where it's come from and why it is as it is. I noted down a lot of the points here with regard to the background, fighting tax fraud and the need for a flow of information. That's all fine. But lies swim along in the current of truth, the saying goes that we have. I think it's good that we have this data exchange, but there are a number of items of collateral damage that weren't initially envisaged. Now, of course, I've taken note of the situation. We have to accept that everyone develops their own tax law as they see fit. That's what the EU does. That's what the US does. It's not about trying to take away someone's founding concepts. There's no dispute over that. Now, we know the situation in the EU. Why has it not been resolved? That's the second issue. And third, I think people who are victims in the EU have fallen victim to a turf war here. If it's an issue of tax law, then the Commission throws its hands up in the air and says, I understand the situation, but it's a member state power. They get put on the wrong shelf, if you like. There are issues here revolving around data protection and citizenship as well, however. And I would almost say human rights. And there the EU is competent. My first appeal or question then, it's almost an appeal anyway, is whether the EU should call a halt to this turf war. There would be a difference if it was each member state going to the US to deal with this, or whether it's the EU. I think it would be much more impressive if it was the EU Commission President or some other taking up the issue. We've seen with customs how important it is for the EU to present itself as such. This is an unbelievable state of affairs, I think we all agree. For those concerned, too little has been done. It's unprecedented and impossible to understand for them. Can you tell us what the main measures that should be undertaken are? I've noted down a couple of them. What are the main measures that we need to undertake to help you out? The first one I noted down, and please put me right if I'm wrong, is that we absolutely need to extend the transitional periods which run out soon under the gentleman's agreement. Secondly, the renunciation declaration, renunciation of US citizenship. That should be made possible and simple and cheaper, somewhat cheaper. Those are some of the measures I've noted down. Are there others that we need to put in place? Thank you anyway for the information that I've taken on board. Thank you.
Muchísimas gracias. Ahora tiene la
Thank you very much. Ms. Ilvel has the floor.
Chair, and I would like to thank all the speakers on the panel. I don't really have a question to you. I think the questions that we all have are questions to the member states and to the European Commission. And of course, when I say member states, I clearly make an exception for France and the Netherlands, which have been very actively standing up for citizens' rights here. But indeed, the other 26 and the European Commission are conspicuously absent. And every time, I've just reread the answer I got from Commissioner Moscovici to a question. It really is downright offensive. It reads as if he feels he has to represent the interests of the United States authorities rather than the interests of what is in essence EU citizens. We're not talking about Americans, no, they're European citizens. So we all have an obligation to stand up for their rights and their interests. What I note, however, is that this whole thing, I mean, it came on my radar screen already back in 2012. Why? Because the banks, French banks in particular, they flagged up that there was a problem and they were getting under pressure. And then the European Commission has tried at that stage to negotiate an arrangement with the Americans, not to protect the interests of EU citizens, but to protect the banks, which is fine. But you know, they've abandoned. I can only hope that the new geopolitical commission of Mrs. von der Leyen is going to bring some change here, because clearly from the national governments we don't have to expect very much. There are several suggestions for, let's say, quick fixes, short-term relief. I note with great irritation that puts the burden exclusively on the individuals concerned. I'm afraid that for now, that is probably the only way that they can get out of trouble. But it is deeply, deeply annoying that the European Commission and most of the member state governments put transatlantic relations over the interests of EU citizens. And as a matter of fact, they accept, and they do so in many policy areas, that US law applies here. And colleague Jara, you just said, and of course you're right, saying that every country has the absolute right to make its own laws, including the fiscal laws. But at the same time, the United States and Eritrea are the only two countries in the world that have citizenship-based taxation. The only two countries in the world. Now, we are an economic superpower. Can somebody please explain to me why we're not using the economic clout of 500 million, well-to-do consumers to convince the Americans to negotiate with us? Why don't we do that in the interest of our own citizens? Because, and I'll conclude on this, this is not just about FATCA, this is not just about accidental Americans, this is very fundamentally about transatlantic relations and the way that the EU operates. Why are we weak? Because 28 government leaders cannot agree. That is the real problem here. It's not a practical problem, it's a political problem. So I think we have to put pressure as much as we can, and believe me, I share, after 8 years, on FATCA, I fully share your frustration about the lack of progress and the lack of will. And again, I welcome the support of the French and the Dutch authorities, but we have to put a lot more pressure, including maybe a call from this committee to the Finnish presidency to speak on behalf of the entire European Union and address this issue with the US.
Thank you very much. We can now give 2 minutes to each of the panelists so that they can answer the questions and considerations voiced by the members. Thank you very much.
Empieza el señor.
Mr. Kaiser can start, or Mr. Janssen, someone?
¿Quién empieza?
Who's going to start?
In order, Mrs. Janssen, the first one.
Okay, thank you, Chair. I don't think that a particular question was raised to me, but maybe to wrap it up from my side, I fully understand the frustration with the US tax system. As I said, I don't think that in the short term that will be changed. So that's why we focus on possible quick fixes. We already got a couple of them. I think we have to recognize that's an important step in the right direction. And it's important to, together with all other member states and the institutions, that we will continue to have action towards the US on the open possible quick fixes that there still are there, like using the fee to renounce your citizenship and to waive for the tax return in some cases and make that process simpler as well. Thank you very much.
Yes, señor Kaiser.
Mr. Kaiser.
Que he tenido más preguntas.
You're the one who had most questions.
So my understanding of the question is that is there any potential to get an extension from the US? It's not easy to answer because, you know, behind all this this discussion, you have the US tax code, and I don't think that we will depart from that. That's one point. But now, from the perspective of European banks, my major concern is about compliance, and we have just to deal with the compliance requirements, and we are of course concerned also by the obligation imposed on some of our clients. They are positive signs. They are positive signs. As you may know, a bill has been tabled at the Congress. So some politicians in the US are concerned by the situation. The FAQ, which was published on the 15th of October, was a very positive sign. And again, as EBF, we welcome this FAQ. Now, in terms of quick fixes, we need more legal certainty. The banks are very concerned that they could be facing very important risks of being considered as being non-compliant, and that would be extremely costly. That would be a very, very big issue. So we need more certainty. We need this, the content of this FAQ to take the form, to be clarified and take the form of a formal notice. And that's the reason why we as EBF sent a letter last Friday to Mr. Mnuchin of the US Treasury. Now, over the long term, we probably need to reopen the discussion on the IGAs. One of the big issues with FATCA is that FATCA is not aligned or not totally aligned on the OECD Common Reporting Standard, which on certain aspects is much more flexible. So that's over the long term something that we wish. That's the reopening of the discussion and a convergence of FATCA and the OECD Common Reporting Standard.
Thank you very much, Mr. Saint-Martin.
Thank you, Madam Chair. Well, one question that was directed concerns 2 points. First of all, 2 points that I want to flag up because they're very shocking to the French National Assembly, at least. In the current situation with the European legislation, fundamental rights have to be guaranteed. Seeing yourself rejected by a bank and a refusal to open an account and have an access to basic banking services is an aberration. Today we have a situation in which the banks transfer personal data of these accidentals without their consent. And this is in contrast to all the regulation that we have adopted on this. And in our European system, therefore, we have a legal aberration. So we have to resolve this legal contradiction. And the second point I'd like to flag up is reciprocity. We were the first country in 2014 to vote in favour of the IGA intergovernmental agreement, and it was ratified by the French National Assembly. I've seen the minutes of the meetings, and Mr. Gallu, who was the rapporteur at the time, explained very well to the French Parliament that this agreement was only valid if there was reciprocity and couldn't just be one way. But the American Congress did not sign the ratification for the American equivalent. So that's a promise, but it has not been implemented. And therefore, I think we have to have a situation in which we can have this block, this force that we could achieve as Europeans. And I agree with what was said by one of the speakers about our frustration at this point, where we're having to undergo these negative consequences for our citizens, where we Europeans are the only ones who've signed this intergovernmental agreement. So I think we've really got to wake up and smell the coffee.
Thank you very much for this panel. I'd like to thank all of you from the bottom of my heart for this very fruitful... Oh, yes, sorry, the petitioner.
Ask a question that's a slightly leading question because it's to come off the points made by Monsieur Le Fur as petitioner. One thing that I'd really like the European Banking Federation to look at, if they haven't done already, which is, I think they made a really good point in the introduction saying CRS, DAC, FATCA, all part of a body of fighting international tax evasion. And we all agree with this, and that's what must be done. But I think there is probably a very distinction, you were making it, which is FATCA serves only US interests, it doesn't serve European interests. Is there not a point, looking at it from the perspective of European banks, to say, what are the costs of these FATCA compliance programs that European banks have to stomach? If you take the FATCA program of BNP Paribas, Crédit Agricole, SocGen combined, it will be billions of US dollars. And very interestingly, PwC, KPMG, all these companies stopped publishing data around this in around 2012. Why don't we look at that data and work out how much European banks are paying to be FATCA compliant and then use that with America to say, this is all money that European banks are hemorrhaging to comply with US norms. Why don't you reciprocate joint CRS? I think there's a very powerful argument there. So it was a slightly leading question, but I don't know what the gentleman from the EBF thinks, but that might be a very powerful bit of data to compile.
Muchísimas gracias.
Thank you very much. Let's do one thing. I'll give the floor to answer this question, and then we can end this panel because there's another panel, and at 2:30 interpretation will end. So we're very pressed for time, so please 1 minute to answer that question, and then we'll move on to the next panel.
Well, I will very rapidly answer. Of course, compliance costs have been a very important argument during the discussions from the beginning. Yeah, but the system is in place now.
No entremos en debate.
We're not going to start a whole debate. So this concludes our first panel. Thank you very much. Thank you to the petitioner and to all speakers for your contributions. I think it was very fruitful, very interesting. We move on to the second panel now with Mr. Fabien Lehagre, President of the Association of Accidental Americans in France, then Mr. Filippo Noceda, partner in Mishcon and visiting professor at King's College London, Alisa Vekman from DG Just of the European Commission, and Ms. Ismini Rigopoulou from the European Data Protection Board. And therefore give the floor to Mr. Lehagre.
Madame la Présidente, Mesdames et Messieurs les députés.
Solo un momento. Si pudiéramos que cada interviniente en vez de 10 minutos acortáramos a 8 minutos, iríamos mejor de tiempo para...
I think it would be better to follow the time as agreed because it would be better for interpretation.
Mesdames et Messieurs les députés.
Madam Chair, ladies and gentlemen, first of all, on behalf of the thousands of accidental Americans that I represent, could I just thank you for giving me this opportunity to give you a detailed presentation of the activities undertaken by civil society. I'd also like to thank the the petitioner Jude Ryan, who started this petition, and the fact that it's still open demonstrates the importance of this topic. Although the first activities by our association began in 2015, we couldn't really take effective action until we became a constituted society, and I did that, Accidental Americans, in 2017. What is an accidental American? Well, by that term we mean those people who, by an accident of their birth, have acquired American citizenship on top of their ordinary citizenship but have no links with the US, who've never lived or worked or studied there. Most of them don't have a social security number. For a more legal definition, we can say that accidental Americans are Americans who do not meet the terms in American law that allow them to pass on their nationality. In other words, they're not able to pass it on because they would need to have spent 5 years in America, including 2 years after the age of 14. These people are regarded as ordinary American taxpayers nonetheless, even if they've never benefited from US infrastructure or have never had any benefits from the US state. It's what we call citizenship-based taxation. Every US national is obliged to pay tax wherever they are in the world, so they have to pass on all their taxation related information, including bank accounts, to the US every year as part of their tax declaration, and that's their taxpayer status, even though they may be American only as a result of family background. They've never had any contact with the US administration who don't really know them because they're effectively French. In 2014, France, like most member states, authorized the approval of a US-French agreement to implement FATCA legislation by dint of French banks. This is extraterritorial US legislation which relates to US taxpayers wherever they may be in the world with the support of financial institutions. Applying that agreement, known as the IGA, entailed huge transfers of personal data to the US, but no derogation was granted to take into account the situation of accidental Americans. Applying this agreement from 2014, financial institutions began sending their customers who were seemingly possibly American forms that they had to fill in, and I received this in November 2014. That's what prompted all this. They asked me to supply my US SSN, a kind of tax identification, or certificate saying that I renounced US nationality. Now, I had neither of those items, as most members of the association in my sort of situation. Those who had a US, who had an SSN, are accidental Americans born after 1986, because that's when it became an automatic procedure. The same applies to other member states that signed IGAs. In May 2017, the Maltese presidency of the Council of the Union took up an initiative I welcome by sending a letter to the US Treasury calling for a moratorium, which was granted on financial institutions having to supply the SSN information, but that moratorium expires on the 31st of December. Thus, from New Year's Day, the banks will no longer be bound by that obligation. The IRS has recently softened its rules, but we may still fear that the threatened withholding of 30% on all their financial flows emanating from the United States may lead them to close bank accounts. In a letter of the 17th of July 2019, the president of the French EBF estimated that 40,000 accounts may be closed by banks, and that's the situation now. So what harm is suffered by an accidental American? Well, firstly, they're unable to meet the requirements of banks, not by bad faith, but simply because they have neither an SSN, a TIN, or a certificate renouncing US nationality. And then their bank accounts, their deposit accounts, get closed because the financial institution regards FATCA requirements as too constrictive, and they would rather either not accept or keep a US account. Most online banks refuse accidental Americans. And then, of course, there's an impediment to banking competition here. And French citizens end up being relegated to second-rank citizens as a result of the whole procedure. There's a financial harm when the person tries to align themselves with US tax rules because they end up spending large amounts of money on lawyers' fees and taxes, and this can run into tens of thousands of euros. Moreover, being described as a US person, which is automatic if you hold US nationality, entails other consequences, such as a reduced access to certain financial products or certain jobs in certain institutions that work with Iran. It also leads to discrimination between wage earners in the same country, whether they're single or binational, or even in a given company. And for that reason, we're not just fighting FATCA as an association, but also extraterritoriality of US law per se. We are, moreover, trying to work with other associations. There's a similar one in Belgium, and there are collectives in the UK, the Netherlands, and Italy as well, and Germany. In France, the association has worked a great deal on communicating the problems faced by accidental Americans, and we've got quite a lot of media attention. But we've also undertaken court action in October 2017 on the basis of the conclusions of a legal study that we commissioned from Professor Regis Bismuth. We have appealed to the Council of State. We were asking for a annulling of the decree dictating a data transfer to the US tax administration. We mentioned the lack of reciprocity in the IGA with the US, and there was a breach of data protection rules. The data protection transfers protect personal data in no way at all, and they do not allow a correction of errors within the data that has been transferred. In 2017, Le Monde, the newspaper, recounted the situation of a French person born in Canada whose information had erroneously been sent to the US tax office. And the Court of Justice of the EU, in its ruling in the Schrems case on the 6th of October 2015, against a data protection commissioner, said that the US were not appropriately protecting the fundamental rights of the individuals used in the processing of their data. And we've asked the French authority here, the high jurisdictional authority, to take action here. Because we feel that they were bound to refer the matter to the court for a preliminary ruling, since there's an issue of EU law here with no jurisdictional appeal under national jurisdiction. For obvious political reasons, we feel that scope is within our reach, which is to refer the matter to the European Commission for it to start infringement proceedings for lack of action against France. In March 2019, the association accompanied 306 accidental Americans in lodging a complaint in the criminal courts against the banks on the basis of discrimination. And there's also been political action. In 2016, there was a first parliamentary report, the Louche-Berger report, on extraterritorial US legislation. And then in May 2019, we got a second report in Parliament, the Le Fur-Saint-Martin report, this time focusing on US tax legislation outside US territory concerning French citizens deemed accidental Americans. In terms of the action to be undertaken at a European level, this report called for the registering of the situation of accidental Americans on the agenda of ECOFIN. And under the Finnish presidency, the matter was tackled in 2 meetings of the tax group. And I can only be happy at that. Time is ticking away. We are now waiting for the European Commission not just to start infringement proceedings against France, but also to take action vis-à-vis the United States to convince it to renegotiate bilateral agreements signed with the member states with a derogation for all dual nationals. Thank you very much for your attention.
Thank you very much. The following speaker, Mr. Filippo, you have 8 minutes.
Does this one work? Yeah. I've been asked to talk to you 10 minutes about why we are doing litigation in my country, that's the UK. And in order to understand that, we need to look at the progress over the last 10 years. So if one looks at FATCA, FATCA was introduced in 2010. Clearly an extraterritorial law, because as a matter of US domestic law, it required foreign financial institutions to transfer the data to the US. The US understood very quickly that they couldn't implement FATCA without the help of other countries. And it became apparent after the Petty report, Mrs. Interveld, Sophie, found letters from the European Commission, and we got them here. So in 2011, you see on the screen, there is a letter from the European Commission written to an accidental American, in which the Commission effectively said that there were concerns about within the EU about FATCA. There are possible issues of conflicts with EU law and member states law, so data protection. That was in 2011. And the cost of compliance, to Jude's point, are worrying. That's the words of a letter from the Commission to an accidental American. And the letter ended in 2011, so 8 years ago, with a hope by the European Commission that one could find legislation that was more proportionate and workable. So already in 2011, the European Commission understood that there was a conflict between FATCA and data protection rules as they applied back then. And that's, of course, is before Schrems. If we then look at another letter that Ms. Sonneveld found, sorry, where do I get it? How do I move this one? Does it move? Voila. In the next email, this is an email from Taxud, so the European Commission again to an accidental American on behalf of Commissioner Šemeta, the European Commission said that the European Commission, together with the Presidency and some EU member states, is currently engaged in a dialogue with the US. So the European Union was concerned because the US were asking the European Union effectively to plug into FATCA on a bilateral nature. And the Commission said, we are concerned, we are discussing with the US. And again, the email ends, we hope that through our work with the US, we are going to find solutions that make FATCA more proportionate and workable. Now, again, it's an admission by the European Commission that FATCA was not proportionate. And what is not proportionate is not necessary, is against human rights. In 2012, Ms. Sonnenfeld found another interesting letter, if I can go back. It's a letter, again, by the Commission to an Accidental America, in which the Commission said that following an in-house examination of, with its own data protection expert, the Commission referred this topic to the Article 29 Working Party, which was, of course, the data protection body issued under the old Data Protection Directive to advise the EU on data protection issues. And it said that the WP29 is working on an opinion. So that is 2012, and that's the law. Now politics take center stage, because if we, sorry, let me try to go here. That was in April 2012. In June 2012, so after 1 month, the Article 29 issued the opinion at the behest of the European Commission that was concerned. And if you look at the report, which I hope it comes up, yeah, it comes up, the report by the European Data Protection Authority finished with, WP29 does not see how compliance with FATCA and the directive, that means the Data Protection Directive, can be simultaneously achieved. And if you read more up, section 8.3, a bulk transfer and the screening of all data is not the best way to achieve a fight against tax evasion. Therefore, more selective, less broad measures should be considered in order to respect the privacy of law-abiding citizens. And incidentally, if one reads the wonderful report, 46 pages report, the Petty issued last year, one reads this, such a restriction against GDPR must respect the essence of the fundamental rights and freedoms and must be necessary and proportionate. That paragraph 5.1 from 2.2 of your report. And the report goes on to say that it appears that FATCA is neither proportionate nor necessary. So effectively, in 2018, the Petty came to the same conclusion that the European Commission and the Data Protection Authority came in 2012. But unfortunately, there's politics, and I am a poor lawyer. So if you look at what happened after a month after the European Data Protection Authorities issued their damning report, the US effectively published unilaterally their model IGA. Effectively, the US accepted in 2010 that FATCA was extraterritorial. They needed the help of partners to plug FATCA into their domestic laws, and so they published these agreements that effectively allow that to happen. And if you look at what happened after that, within 2 months, the first countries, the first member state, jumped on the FATCA bandwagon. They did so ignoring the concerns of the Commission. They did so ignoring the concerns of the advice, of legal advice of the data protection authorities. They did so because a lot of European banks had problems with the US because of past issues. They had multi-billion-dollar fines, and therefore the Commission and the member states were very happy to conclude these things. So the problem is that there was then a change of direction. So you remember the first email where the Commission said that we are concerned about FATCA. What happens next is that in I don't know if it's in this room, but last year at a hearing you had, a member of the European Council said it is not the role of the Council to evaluate the impact of intergovernmental agreements concluded by member states because they are bilateral agreements. When in 2011, the Council was talking to the US, effectively they said nothing to do with us anymore. And I think that is offensive if you look at it from a perspective of a tax-abiding citizen. Even the Commissioner said, well, first, thank you for making us aware of the difficulties faced by accidental Americans. These difficulties had been known for 9 years. But what she then said is, let me reiterate that the Commission was not part in the negotiation with the US with the rules implementing FATCA in the member states, which remain a member state competence. And here I disagree, and the Commission said it in emails in 2011. We are talking to the US, and it's not about taxation, it's about GDPR and it's about human rights. Fundamental to this issue is the concern that an automatic bulk exchange of data, regardless of any indicia of tax evasion, it's effectively transparency without any ability for the right to privacy. And this is where the Petty Commission got it right. You had your report. And unfortunately, it seems to us that a number of European bodies turned their blind eye to the issue. Even if you look at the EDPB, which took on from the W29, their position became much more nuanced. Now it's about tiny compliance, and they forgot all about the fundamental right. But we knew also in the press that this is an article from The Economist in 2014 that FATCA was seen as
Tendría que ir terminando.
I'm going to have to ask you to wrap up.
Seconds? Okay, then fine. Then we have a legal challenge in the UK. It's a lady who earns less than $104,000 and therefore she does not have to pay tax in the US. She asked the UK tax authorities for information. They denied information on the basis that disclosure would prejudice interest with another country, so it's politics instead of human rights. She is crowdfunding to keep this in the public domain. We want accountability because the Washington Post said last year, and that's an article, that their IT system is a disgrace. They got a computer system from the 1960s. And I think that given that the Commission has not listened to the concerns from the Petty Commission, I think that you should ask for infringement proceedings because member states are clearly violating EU law, and the Petty Commission has defined the issues. Thank you very much.
Thank you very much. The speakers had 10 minutes each, but since the interpreters have to leave at 12:30, we have reduced the time to 8 per speaker. So now the floor goes to Ms. Elisa Weckermann. And please, if you could keep it to 8 minutes. Thank you very much.
Okay, thank you very much and good morning. I will say a few words on the EU's data protection rules in general and then focus specifically on the handling of personal data and in the context of FATCA and the safeguards that apply in this area. So as you all know, and it was mentioned already several times, the EU has recently reformed its data protection rules, and the General Data Protection Regulation, or the GDPR, entered into application last year. The GDPR has replaced the rules that were previously in place under the Data Protection Directive, which were there for more than 20 years. And while the GDPR has further harmonized and updated those rules, it has not radically changed what was in place before. So the GDPR sets out certain key data protection principles and obligations for those that handle personal data. This concerns both private operators and public authorities. So, for example, the GDPR provides certain principles like the principle of purpose limitation, data accuracy, requires appropriate security measures to be in place.
Excuse me, slow, please, for the...
Sorry.
Yeah, don't worry, a little bit. Okay, thank you.
Sure. And it also provides individuals with certain rights. For example, the right to obtain access to one's personal data or the right to obtain a correction or a deletion thereof. And then finally, what is also relevant in this specific context is that the GDPR also sets out specific rules for transfers of personal data to third countries or international organizations. And there, the underlying principle is that whenever personal data is sent to a third country, then individuals in the EU should continue to benefit from data protection safeguards. And of course, both financial institutions and national authorities in the EU are fully subject to the GDPR, and they have to comply with its obligations, including when they handle personal data in the context of FATCA. So turning now specifically to the data protection safeguards that apply in the context of FATCA, these are actually provided through a combination of different instruments, through international agreements, administrative arrangements, national implementing laws, and also other international instruments in the area of cooperation in tax matters. So first, as was already highlighted before by previous speakers, FATCA has been implemented by the member states through bilateral agreements signed with the US. And these agreements, in turn, they refer to confidentiality and other protections that are provided in other agreements signed between the US and the member states. For example, in many cases, this refers to the Council of Europe or OECD Convention on Administrative Assistance in Tax Matters. And this convention and other bilateral treaties contain safeguards to ensure that any information that is shared with the US is only exchanged when this is relevant and necessary. And it also imposes certain limitations on the further use and disclosure to third parties of the information once it has been received, in this case by the US. And finally, this convention also stipulates that nothing in there affects the rights or the safeguards that are provided to individuals by national law. So, of course, this then means that both member state authorities and financial institutions in the EU remain fully subject to the GDPR. And this includes the obligations to comply with data protection principles, to ensure transparency, and to allow EU individuals, including EU individuals with double nationality, to exercise their rights. In addition to that, national laws that further implement these international agreements, they may further specify the obligations for financial institutions and national authorities when they collect and report information in the context of FATCA. So, for example, there are national laws that impose very specific transparency obligations towards individuals, or, for example, set a maximum period for which personal data may be kept. In addition to that, all redress mechanisms under the GDPR are available to EU individuals, so to any individual in the EU, not just EU citizens. This means that individuals can also obtain access, correction, or deletion of their personal data and can lodge a complaint with national data protection authorities. And of course, they can also obtain judicial redress before the national courts in the member states. To our knowledge, no complaints have been lodged so far with the data protection authorities in the EU. That said, the data protection authorities looked into this matter, and last year they came to the conclusion that at the time there had been no occasions where they had to intervene or where they had to prohibit the processing of personal data in this context. And of course, they are the independent enforcers of the EU data protection rules at national level, and they are therefore best placed to assess the situation in practice. The European Commission does participate in the meetings of the European Data Protection Board, which is the body that brings the national data protection authorities together at EU level. And we are, of course, closely following any developments on this file and any discussion that takes place there. As I said, while at least to our knowledge, there have been no complaints with national data protection authorities, there has been litigation. And as was already mentioned, other judicial proceedings are ongoing in the member states. And in this respect, looking at the litigation that has already taken place, I would like to point out that, in fact, the highest administrative court in France, the Conseil d'État, this summer issued a judgment where it looked specifically at the French agreement with the US under FATCA and came to the conclusion that it did not violate the GDPR or the EU Charter of Fundamental Rights. And in particular, it's interesting to note there that the Conseil d'État actually notes that US law also provides for certain data protection safeguards in this area. In particular, the Conseil d'État referred to the possibility to obtain access and correction of the personal data of US citizens, including those that live in the EU. And the Conseil d'État also referred to the possibility to obtain judicial redress before the American courts in this context. So, of course, it's in light of all of these developments that the Commission is also currently looking at the complaint because, as was already mentioned, a complaint has now been lodged also with the European Commission against, in the context of the French agreement. We have received this complaint a few weeks ago. We have confirmed to the complainant that the complaint has been registered and is being looked at. And we will carefully assess this complaint in accordance with the usual procedure. Thank you. And sorry if I spoke too fast, but at least I'm within the time limit.
Thank you very much. The floor now goes to Ms. Wickman, says the speaker.
Pardon.
Apologies. Ms. Ismini Rigopoulou from the European Data Protection Board.
Thank you, Madam Chair. So thank you also for inviting the EDPB here today at this audition on this very important topic. So I will first start by presenting the work of the EDPB and its predecessor, the Working Party 29, until now on the automatic exchange of personal data in the context of tax purposes, and more specifically with regards to FATCA. And then I will move on to speak a little bit about the ongoing work of the EDPB on this subject. So indeed, the EDPB and the Working Party 29 have taken several actions with regards to FATCA and the automatic exchange of personal data for tax purposes in the past 7 years. As was already mentioned partly, the EDPB and the Working Party 29 has published 6 documents since 2012, including letters, statements, and guidelines. So first, I will start with the letters in 2012 that the Working Party 29 addressed to the tax unit of the European Commission. In these letters, the Working Party 29 underlined the need for a legal basis to ensure the lawful processing of personal data within the scope of FATCA. We also highlighted that the absence of such a legal basis could lead to national data protection authorities to prohibit the data processing in question, here the transfer of the personal data to the US, as this would be a violation of the very essence of data protection law. At the same time, we emphasized that such a legal basis should not only be established, but it should also be in compliance with all the principles and safeguards provided with data protection law. To achieve this compliance with data protection law, the legal basis, which could be provided through a legally binding agreement, should include all principles and safeguards included before in the directive and today in the GDPR. So as an example, the principles of proportionality, necessity, security, and data retention should be respected. And in addition, the purpose of the processing of such data should be clearly defined. Data subjects should be provided with data protection rights and effective redress mechanisms to exercise these rights. So in line with the Working Party 29's recommendations of 2012, 1 year later, the European member states started signing the intergovernmental agreement with the US governments, providing as such for a legal basis for the exchanges of personal data in the context of FATCA. Most of such agreements, as was previously mentioned, were concluded between 2013 and 2016. In 2015, the Working Party 29 published a new statement, as well as a set of guidelines recalling the data protection principles and safeguards to be respected in cases of interstate exchanges of personal data for tax purposes. These documents, of course, also addressed the issue of FATCA. More specifically, these guidelines were elaborated to draw the attention of national governments on the need that such exchanges should meet data protection requirements set forth by EU law, with particular regard to the principles of necessity and proportionality. 3 years later, in 2018, the Working Party 29 answered to the requests of the Association of Accidental Americans here present to provide its views on FATCA, and especially regarding the position of accidental Americans with regards to this legislation. The Working Party responded to these requests, first of all, reminding all the previous actions between 2012 and 2018. We also highlighted that there had been, and there still has not been until today, any occasion where a national data protection authority has had to prohibit the processing and transfer of personal data to the US under the FATCA regime. Now, regarding the question of the scope of application of FATCA, the Working Party 29 highlighted that it was not the appropriate body to address this question, and the same stands today for the EDPB. The Working Party 29 recalled the available possible recourse avenues for accidental Americans and other interested stakeholders. Indeed, any complaint should be addressed to national data protection authorities in case of a violation of the handling of personal data in the context of FATCA. In addition, other legal avenues are available, such as the possibility to take recourse before national courts, which I believe the Association of Accidental Americans has already done through the Council of State in France. At this point, I would like to highlight that until today, also no data protection authority has received any complaint regarding the exercise of individual rights on FATCA, nor regarding the compliance of the intergovernmental agreements with data protection legislation. Now, moving on to the current work of the EDPB, I think it is important to first clarify that the EDPB can adopt general guidance to clarify the terms of European data protection laws in order to give stakeholders a clear and consistent interpretation of their rights and obligations. So the EDPB, instead of answering specific individual requests, issues general guidance. So in line with this competency, we are currently working on the elaboration of guidelines on Articles 46.2a and 46.3b of the GDPR. As mentioned in our statement of January 2019, in response to the resolution adopted by the European Parliament in June 2018, we are currently working on international transfer tools that can have an impact on FATCA. More specifically, the EDPB aims with these guidelines to provide specific and useful guidance for the preparation, conclusion, and, if necessary, amendment of legally binding and enforceable instruments signed between public authorities or bodies. These guidelines should therefore prove useful for public authorities and member states according to the principle of accountability introduced by the GDPR to ensure and demonstrate compliance of the intergovernmental agreements signed with the US with data protection legislation. These guidelines will hopefully help member states evaluate their intergovernmental agreements and, if necessary, amend them to align them with the GDPR requirements. We are hoping that this ambitious work on these guidelines will be finalized by the first quarter of 2020. These guidelines will be open for public consultation for a period of 6 to 8 weeks before their final adoption after that. Thank you very much.
Thank you very much. And now give the floor to the members of the committee. Would anyone like to take the floor? Any member of the committee? Yes.
Thanks very much. I have to say that sometimes this whole debate about FATCA can feel a bit Kafkaesque. Like Sophie said, the burden, it falls at every point on the shoulders of the individual to find their way through the maze of the legal framework and the different laws which, whether it's data protection or banking laws or intergovernmental agreements, to find their way through the whole myriad. And at every point, they're told you have the option for redress. But it assumes a lot of resource and capacity for the individual to actually be able to defend their rights. And it doesn't feel like that question is addressed at all in this discussion. So that's just a first point. My question is whether people feel that there's as a result of all of the bilateral agreements, and I read between the lines of what was said in the last presentation that there may be intergovernmental agreements which do need to be revised as a result of the guidelines, and therefore there is a different dimension for accidental Americans in each member state. So my question would really be, to what extent are we facing a kind of postcode lottery for European citizens? That actually the legal framework differs quite considerably depending on which member state you're in relation to data protection. And to what extent is that a worry for the European data protection authorities, where you would be wanting to have a real harmonised European framework? I raise that question because I'm just reading between the lines of the official presentations of the things which are being planned that suggest that that is the case at the moment. And I have to say, I really congratulate a colleague from Mission Dorea for laying out the treasure trove of documents that Sophie has unearthed through the last few years, showing the shifts in attitude in the institutions. But the real concern, I guess, today, and definitely in terms of data protection, is do we have a postcode lottery? And if we do, what action, concrete action, is going to be taken to address that?
Peter.
Thank you very much. Peter, please.
I think
that's precisely the point. And maybe that's today's conclusion. I've noted down that you've got a citizenship you don't want. And secondly, from my point of view, we shouldn't continue the original mistake. The original mistake was that we said to the bank system that they had to enforce tax law. And every member state does it for themselves. My suspicion is maybe the Commission was right then. They shouldn't have dealt with the problem, and they said it wasn't to do with us. That's what one might say, but I think that's in fact wrong in the final analysis, because this is all about consumer interest, consumer protection, and that's an eminently European interest, and the Commission has to do something about it. I think it has a different impact if the Commission speaks on behalf of 500 million citizens. We shouldn't allow this issue to be dealt with bilaterally. That will just make it even more awry. The Americans will be faced with people living in France, Germany and Greece. To sum up, I think we need to write an urgent letter to the Commissioner saying that you've got to take up your responsibility, to live up to your responsibility for EU citizens. These accidental Americans belong to us, and the Commission must finally take action.
Thank you, Ms. Infeld.
Madam Chair, and thanks again to the presentations by the panelists. I'm glad to see that Mr. Noceda has made very good use indeed of the the documents that we have unearthed. Two questions, although I recognise they're largely rhetorical, to the Commission. One is, you refer to legal remedies. Exactly what legal remedies are you talking about? So, because the problem here is that somebody in Europe is being excluded or doesn't get access to banking services in Europe. And you're referring to legal remedies in the United States. On what exactly? It's nonsense. Secondly, the Commission has always maintained that this is a tax matter, and therefore it can only be resolved with bilateral agreements, as taxation is a purely national competence. But that's nonsense. It's not a tax matter. The IGAs have been concluded for the purpose of data protection, for compliance with EU data protection rules, which is an exclusive European competence. So it's absolute baloney. There's every reason the European Commission can propose an EU-US agreement for the purpose of securing the rights of EU citizens. Got nothing to do with taxation. Now, I recognize that you're probably not going to answer this question, but I do hope that you pass it on to the politically responsible commissioners and soon-to-be commissioners. Thank you.
Muchísimas gracias.
Thank you very much. I would give the floor now to Ms. Elisa Beckman, because all the questions have been for her.
Yes, thank you very much. First, with respect to the comments on potential risk of different approaches in the member states, I think this is also one of the points that was raised at the time in the resolution of the Parliament. And that I just want to say that right now we have no indications that there would really be a discrepancy in how individuals are treated or how personal data is treated from a data protection point of view. Because, as already was explained here, except for one member state, all of the member states have concluded the same type of model agreements with the United States. And they are also parties to very similar bilateral agreements, or, as I mentioned before, the Council of Europe OECD Convention in this area, which contains very similar safeguards. When it comes to data protection, the GDPR is a regulation that applies across the EU in the same way. There is no possibility to differentiate in this area, well, at least in the area of taxation. So we have no indications that there would be this different approach. At the time when these international agreements were concluded, the data protection authorities in many member states were also involved. They gave opinions on this. In some cases, they approved this. And as was already mentioned here last year, just last year, the data protection authorities came to the conclusion at EU level that there had been no situations where they had to intervene in this case. And they did this in a public statement of the European Data Protection Board, which is the body that brings together all those authorities precisely to avoid that there is a different approach in the area of data protection at EU level. Then perhaps to come back to also to the points that were raised on legal remedies. I was, of course, my presentation was purely about data protection aspects. I wanted that to be clear. What I referred to was the legal remedies that are available under the GDPR in the EU against financial institutions and national authorities in the member states. And then, as the Conseil d'État also pointed out in its judgment of this summer, when it comes to data protection, there is legislation in the US that governs what public authorities, how they handle personal data, and that provides for judicial redress for US citizens, including ones that do not live in the US. And then I think the other questions were more about access to financial services and more about taxation. So if the relevant colleagues from the Commission who are present here today want to intervene on that, I will leave it to them to reply. Thank you.
¿Hay algún miembro?
Would any member?
The Commission that wants to. Si no, daríamos.
If that's not the case, we can close this agenda item. I would like to thank the petitioners, all speakers, panelists. But what I want to say in the name of the Petty Committee that you've seen, the name of all the members of the different political parties, we all agree that this needs to be solved. We need to give an answer to EU citizens on this matter. So you can rest assured that this Petitions Committee isn't going to abandon you, quite the contrary. And this committee is precisely the bridge between European citizens and the institutions, not only Parliament, but also the Commission and the Council. Therefore, we, the Petitions Committee, will be asking the European Commission to truly find a solution, and we cannot turn our back on European citizens. This is a request made by the European Parliament, by this committee, to the European Commission. Therefore, the European Commission will be receiving from this Petitions Committee everything that has been discussed today and the conclusions we've reached and the many proposals that have come out. We therefore ask the European Commission to give a solution to European citizens who suffer from this serious problem. Thank you very much.
Let's take up my suggestion to also write to the Finnish presidency and
Yes, of course.
encourage them to.
Yeah, of course. And of course that, after this November, we will have the new commissioners. Our commissioner is the Vice President Šefčovič. He compromised with us, with our petty committee, to come once every 6 months or once every year here. So we will do this. We are going to conclude with everybody, with all that we say today here, to the new commission.
I mean, the Finnish presidency, which is the council, and there I don't think we need to wait. Quite the opposite. We need to write to them as quickly as possible and support, because the Dutch and the French are trying to get the Finns to take initiatives on behalf of the EU, and I think we should endorse that.
Okay, yeah, we'll do it. Perfect. So thank you very much to everybody. Finish this hearing. Thank you very much.